Dylan Roof. Most mass shootings happen fast. The attacker arrives, the violence begins, and within minutes, it is over. What happened at a church in Charleston on June 17, 2015 was different. The shooter did not storm in firing. He walked through the front door, introduced himself, and sat down for Bible study. He sat with those 12 people for close to an hour. He listened to their prayers, watched them open their Bibles, and according to his own statement to federal investigators afterward, he nearly called the whole thing off because the people in that room had been so welcoming that he almost could not bring himself to do what he had come to do. He did it anyway. He drew a Glock 41 and fired 88 hollow-point rounds into the room. 9 people were killed. 3 survived by lying still under the dead. Mother Emanuel, as the church was known, had roots stretching back to 1816. Dylan Roof chose it deliberately. He was a 21-year-old self-radicalized white supremacist, and he later told investigators his goal was to start a race war. Federal agents recovered a website Roof had built called lasterhodesian.com, containing a written manifesto, neo-Nazi imagery, and photographs of him posing with a Confederate flag and the same Glock he carried into that church. He was arrested the next day during a traffic stop in Shelby, North Carolina, roughly 200 miles from Charleston. He did not resist. In December of 2016, after a 4-day federal trial in the United States District Court in Charleston, a jury convicted him on all 33 counts, including 9 counts of hate crimes resulting in death. He chose to represent himself during the penalty phase. He called no witnesses, offered no apology, and gave no explanation. He did not ask the jury to spare his life. On January 10, 2017, they unanimously sentenced him to death. He became the first person in American history to receive a death sentence under federal hate crime statutes. That same spring, he separately pleaded guilty to 9 state murder charges and received 9 consecutive life sentences, essentially an insurance policy in case the federal sentence was ever overturned. A jailhouse journal recovered during the investigation contained an entry where Roof stated plainly that he did not regret what he had done, that he was not sorry, and that he had not shed a tear for the people he killed. The Fourth Circuit Court of Appeals unanimously affirmed his conviction and death sentence in August of 2021, declaring in their opinion that his crimes qualified him for the harshest penalty a just society can impose. The Supreme Court declined to hear his case in 2022. In April of 2025, his defense team filed a new motion seeking a fresh penalty phase trial based on alleged juror disqualification issues. That motion remains pending. When President Biden commuted the sentences of 37 federal death row inmates in December of 2024, Roof was one of 3 he specifically left out. The reason cited was that his crime constituted hate-motivated mass murder. He remains at USP Terre Haute in Indiana. In April of 2026, the Department of Justice formally readopted the pentobarbital lethal injection protocol and authorized firing squads as an additional execution method. Roof is widely considered one of the most likely candidates to be executed first under this reactivated protocol. And somehow, it gets worse from here, because Roof was not the only person on federal death row for a mass killing driven by ideology. The next case involves a pair of brothers, a pressure cooker, and the finish line of one of the most watched sporting events in the country. Dzhokhar Tsarnaev. On April 15, 2013, roughly 23,000 runners crossed through downtown Boston for the 117th running of the Boston Marathon. Hundreds of thousands more lined the streets. It was Patriots' Day in Massachusetts, a state holiday, and the finish line on Boylston Street was packed with families, friends, and spectators. At 2:49 in the afternoon, 2 homemade pressure cooker bombs packed with nails, BBs, and shrapnel detonated near the finish line, 14 seconds and roughly 210 yards apart. The blasts tore through the crowd. 3 spectators were killed. Crystal Marie Campbell, 29, a restaurant manager from Arlington. Lingzi Liu, 23, a graduate student from China studying at Boston University. And Martin William Richard, 8 years old, from Dorchester, who had come to watch the race with his family. More than 260 others were wounded. 17 of them lost limbs. The men responsible were brothers Dzhokhar and Tamerlan Tsarnaev, Chechen-American immigrants who had been radicalized through Al-Qaeda's online magazine Inspire. Dzhokhar was 19 at the time. Tamerlan was 26. For 3 days, the city of Boston lived under a kind of siege. The FBI circulated surveillance footage of the 2 men carrying backpacks near the finish line. On the night of April 18th, the brothers shot and killed MIT police officer Sean Collier, who was 27, as he sat in his patrol car. They then carjacked a graduate student named Dun Mung at gunpoint, stole his Mercedes, and led Watertown police on a running gun battle through residential streets in the middle of the night. Tamerlan was wounded in the firefight and then run over by his own brother, who was fleeing in the stolen car. He died at the hospital. The following evening, after a day-long shelter-in-place order that shut the entire Boston metropolitan area down, a Watertown resident noticed blood on his dry-docked boat in the backyard. Inside, police found Dzhokhar Tsarnaev. He had scrawled a message on the interior wall, calling the bombing victims collateral damage for American military actions in Muslim countries. His trial began in January of 2015. His defense attorney, Judy Clark, conceded his guilt in her opening statement and focused the defense entirely on Tamerlan's influence, arguing Dzhokhar was a follower, not a leader. The jury convicted him on all 30 counts on April 8, 2015. On June 24, 2015, he was formally sentenced to death on 6 of those counts. He addressed the courtroom briefly and offered what his attorneys characterized as an apology. This is where the story takes a turn nobody expected. In July of 2020, the First Circuit Court of Appeals vacated Tsarnaev's death sentence entirely, ruling that the trial judge had failed to adequately screen jurors for bias and had improperly excluded evidence about the 2011 Waltham triple murder, which was allegedly tied to Tamerlan. The ruling meant that Tsarnaev's conviction stood, but the death sentence did not. If it held, he would have been resentenced to life in prison. The Trump DOJ appealed. The Biden DOJ, despite the new administration's stated opposition to the federal death penalty, continued that appeal. And in March of 2022, the Supreme Court reinstated the death sentence 6-3 in United States versus Tsarnaev, with Justice Thomas writing for the majority and Justices Breyer, Sotomayor, and Kagan dissenting. That should have been the end of the legal road. It was not. In March of 2024, the First Circuit ordered the trial judge to investigate 2 jurors who had allegedly concealed hostile social media activity. One had shared content online calling Tsarnaev a piece of garbage before the trial. Another had a social media contact who had urged them to get on the jury. That fact-finding inquiry remains pending as of 2026. Biden did not commute his sentence. He is held at the ADX Florence Supermax facility in Colorado, and his execution cannot move forward until the juror inquiry is resolved. That juror investigation is the only thing standing between Tsarnaev and a federal execution date. In July of 2025, the First Circuit denied his attorney's bid to remove the original trial judge from overseeing the inquiry, meaning the same judge who presided over the trial is now investigating whether his own juror screening was adequate. Meanwhile, the man responsible for the deadliest anti-Semitic attack in American history was tried, convicted, and sentenced to death during the same window of time, and his appeals are only just beginning. Robert Bowers. On Saturday morning, October 27, 2018, 3 separate congregations had gathered inside the Tree of Life Synagogue in the Squirrel Hill neighborhood of Pittsburgh for Shabbat services. Tree of Life, New Light, and Dor Hadash, all sharing the same building. Squirrel Hill is the historic center of Jewish life in Pittsburgh. It has been for over a century. It was an ordinary Saturday morning. Some of the worshipers had attended services at that synagogue for decades. Some had been members their entire adult lives. Minutes before the shooting began, a 46-year-old truck driver named Robert Bowers posted a message on the social media platform Gab. He referenced HIAS, a Jewish refugee resettlement organization, and wrote that he could not sit by and watch his people get slaughtered. He said he was going in. Nobody reported the post before he arrived at the synagogue. He entered the synagogue armed with a Colt AR-15 rifle and 3 Glock pistols. Over roughly 20 minutes, he fired the rifle 75 times and a pistol 17 times. 11 worshipers were killed, making it the deadliest anti-Semitic attack in American history. 6 others were wounded, including 4 responding police officers. Bowers himself was shot multiple times during the firefight with police before he was taken into custody. He survived. Among the dead were Joyce Feenberg, 75, a retired University of Pittsburgh research specialist; Richard Gottfried, 65, a dentist; Rose Mallinger, 97, the oldest victim; Dr. Jerry Rabinowitz, 66, a primary care physician who had been known in the 1980s for treating HIV patients without wearing gloves when other doctors refused to touch them; Cecil and David Rosenthal, 59 and 54, brothers with intellectual disabilities who were beloved in the congregation for greeting everyone who walked through the door; Bernice and Sylvan Simon, 84 and 86, a married couple who had been wed at that same synagogue back in 1956; Daniel Stein, 71, Melvin Wax, 87, who had been leading the service that morning, and Irving Younger, 69, the synagogue greeter. Bowers was charged with 63 federal counts, 22 of them carrying the death penalty, including obstruction of free exercise of religion resulting in death. He offered to plead guilty in exchange for a life sentence. The Department of Justice, under both the Trump and Biden administrations, refused the deal. The government wanted death. His trial began in May of 2023 in federal court in Pittsburgh before Judge Robert Colville. His defense attorney was Judy Clark, the same lawyer who had represented Tsarnaev in Boston. Clark emphasized Bowers's diagnosed schizophrenia, epilepsy, and evidence of brain abnormalities revealed through neurological testing. The jury convicted him on all 63 counts on June 16th. On July 13th, they found him eligible for the death penalty. On August 1st, 2023, they unanimously recommended death. The judge formally imposed the sentence 2 days later, telling the courtroom there was nothing he could say to the defendant that might be meaningful. Bowers showed no emotion and made no statement. To put that in plain terms, a man walked into a synagogue on a Saturday morning, murdered 11 people during worship, and when given the chance to speak at his own sentencing, said nothing. The jury needed no additional deliberation. His was the first federal death sentence handed down during the Biden administration's moratorium on executions. His automatic appeal to the Third Circuit is still pending. No Supreme Court ruling has yet addressed his case. Biden excluded him from the December 2024 commutations, alongside Roof and Tsarnaev, citing the same carve-out for terrorism and hate-motivated mass murder. He is currently held at USP Terre Haute. As of 2026, no execution date has been set for Bowers, Roof, or Tsarnaev, though the DOJ's April 2026 protocol announcement makes all three eligible once their appeals are exhausted. Those three men are the only inmates remaining on federal death row. They are the three Biden refused to spare. They are the three Trump's executive order prioritized. And yet there was a fourth case, prosecuted under the exact same federal death penalty framework, where the outcome was entirely different. If you are finding this video interesting, consider subscribing. It really helps to grow my channel, so I can cover cases like these every week. Sayfullo Saipov. On the afternoon of October 31, 2017, a 29-year-old Uzbek immigrant named Sayfullo Saipov rented a pickup truck from a Home Depot in Passaic, New Jersey, drove it into Lower Manhattan, and at 3:04 in the afternoon, swerved onto the Hudson River Greenway bike path along West Street. Saipov had entered the United States in 2010 on a diversity immigrant visa. He had lived in Ohio, Florida, and New Jersey. By the fall of 2017, he had been planning this attack for a year. Over roughly 1 mile, accelerating to 66 miles per hour, he struck cyclists and pedestrians before crashing into a school bus near Chambers Street. 8 people were killed. 11 more were injured. 5 of the dead were members of an Argentine high school graduating class who had traveled to New York to celebrate the 30th anniversary of their graduation. Hernan Mendoza, Diego Angelini, Alejandro Panuco, Ariel Erli, and Hernan Ferrucci, all in their late 40s, lifelong friends reuniting in a city they had dreamed of visiting together. Belgian tourist Anne-Laure Descartes was 31. She had a husband and 2 young children back home. Americans Nicholas Cleaves, 23, a lifelong New Yorker, and Darren Drake, 32, from New Jersey, who had been riding a city bike on his lunch break, were also killed. After crashing the truck, Saipov climbed out holding a paintball gun and a pellet gun. NYPD officer Ryan Nash shot him in the abdomen, and he was taken into custody. Inside the truck, investigators found a handwritten note pledging allegiance to ISIS and a black ISIS flag. He told the FBI during questioning that he had been planning the attack for a year and asked that an ISIS flag be hung in his hospital room. The day after the attack, then-President Trump publicly stated that Saipov should receive the death penalty. Saipov was charged with 28 federal counts, including murder in aid of racketeering and providing material support to a foreign terrorist organization resulting in death. The Trump DOJ certified the case for the death penalty in 2018. The Biden DOJ continued the prosecution. Trial began in January of 2023 in the Southern District of New York. On January 26th, the jury convicted him on all 28 counts. The case then moved to the penalty phase, which concluded on March 13, 2023. And this is the part that makes the Saipov case fundamentally different from Roof, Tsarnaev, and Bowers. The jurors unanimously found that the attack was premeditated. They unanimously found multiple aggravating factors, but they could not unanimously agree that Saipov posed a continuing future danger. Under federal law, A death sentence requires unanimity on at least one aggravating factor that warrants death. That deadlock automatically converted the sentence to life without the possibility of parole. One juror's hesitation on one legal question, and the outcome flipped entirely. On May 17, 2023, the judge imposed 8 consecutive life sentences, plus 260 years, and 2 additional concurrent life terms. Before sentencing, Saipov addressed the courtroom in Uzbek for nearly an hour, defending jihad, praising ISIS, and expressing no remorse for what he had done. The sister of Anlor Dekat stood and told him directly that the only act of the devil in that courtroom was the act he had committed. The judge called it among the worst conduct he had ever encountered in his career on the bench. You would think someone would have said something. Nobody did. That is the strange reality of the federal death penalty. The same statute, the same DOJ certification, the same kind of ideologically motivated mass killing. Roof's jury was unanimous. Tsarnaev's jury was unanimous. Bowers's jury was unanimous. Saipov's jury deadlocked on a single question, and a man who killed 8 people in an ISIS-inspired attack will live out the rest of his natural life at the most secure prison in the country. Saipov is at ADX Florence. He is not on death row. He was unaffected by Biden's commutations and unaffected by Trump's executive order. His case is closed. The next case is different in almost every way. No ideology, no manifesto, no mass attack. Just 3 women, a remote stretch of federal land, and a man who never pulled the trigger but received the harshest sentence of anyone involved. Dustin Higgs. On the night of January 26, 1996, a 23-year-old man from Laurel, Maryland named Dustin Higgs drove with 2 friends, Willis Haynes and Victor Gloria, to Washington, D.C., where they picked up 3 young women and brought them back to Higgs's apartment. Tamika Black was 19. Tanji Jackson was 21. Mishan Chin was 23. They spent the evening together, drinking and listening to music. When Tanji Jackson turned down Higgs's advances, the women decided to leave. Higgs offered to drive them home. Instead, he drove to a remote section of Route 197 inside the Patuxent Research Refuge in Prince George's County, Maryland. It was federal land. That jurisdictional detail would determine everything that followed. According to the prosecution's case, Higgs handed Willis Haynes a .38 caliber pistol and told him to make sure they were dead. Haynes shot all 3 women in the chest and the back of the head. A passing motorist found their bodies the next morning on the roadside. The case went unsolved for nearly 3 years. There were no witnesses, no surveillance cameras, and no physical evidence tying anyone to the scene. It was not until 1998, when Haynes and Gloria were arrested on unrelated charges, that both men gave statements to investigators implicating Higgs as the one who ordered the killings. And no, I'm not making this up. The man who actually pulled the trigger, Willis Haynes, was tried separately and received life in prison plus 45 years. Victor Gloria, who was also present, pleaded out and served just over 5 years. Dustin Higgs, who the prosecution said gave the order, but who never personally fired a shot, was indicted federally in December of 1998 and went to trial in the fall of 2000. The jury convicted him on all counts, including 3 counts of first-degree premeditated murder, 3 counts of kidnapping resulting in death, and related firearms charges, and on October 26, 2000, recommended 9 death sentences. It was the first federal death sentence ever imposed in the state of Maryland. To put that in perspective, Maryland abolished its state death penalty entirely in 2013. The only reason Higgs faced capital charges at all was because the killings happened on a patch of federal land. His appeals were exhausted by December of 2012, and he sat on death row without an execution date for years because of the de facto federal moratorium that had been in place since 2003. He waited nearly 2 decades. Higgs's case became the most contested of the 13 federal executions carried out during Trump's first term. Nearly 2 million people signed a petition asking for clemency. 5 of the original jurors, along with former federal prosecutors, called for his sentence to be reduced. His lawyers argued the disparity was grotesque. The triggerman gets life, the man accused of giving the order gets death, and the whole thing hinged on the testimony of the 2 co-defendants who had the most to gain by pointing the finger at Higgs. Maryland had abolished its state death penalty in 2013, meaning that if this exact crime had occurred 50 yards in a different direction, off federal land, the death penalty would not have been an option at all. In the final days of Trump's first term, as the administration carried out federal executions at a pace not seen in over half a century, more federal executions in 6 months than in the previous 56 years combined, Higgs tested positive for COVID-19 just weeks before his scheduled execution date. His legal team sought emergency stays. On January 15, 2021, the Supreme Court vacated a lower court stay in a 6-3 decision. Justice Sotomayor wrote in her dissent that this was not justice. On January 16, 2021, 4 days before Trump left office, Dustin Higgs was executed by lethal injection at USP Terre Haute. He was pronounced dead at 1:23 in the morning. He was the 13th federal inmate executed since July of 2020, when Attorney General William Barr resumed federal executions after a 17-year pause. In his final statement, Higgs named each of the 3 victims individually: Tamika Black, Tangi Jackson, and Mishan Chin, and maintained that he was an innocent man, that he was not responsible for their deaths, and that he did not order the murders. He was the final federal execution of Trump's first term. As of 2026, he remains the last person executed by the United States federal government. Daniel Lewis Lee. On the morning of July 14, 2020, a man who had been strapped to a gurney for nearly 4 hours inside the execution chamber at USP Terre Haute was finally injected with a single dose of pentobarbital. He was pronounced dead at 8:07 in the morning, Eastern Time. His name was Daniel Lewis Lee. He was 47 years old, and he was the first person executed by the federal government in 17 years. The case that put him there began on the night of January 11, 1996, in the small town of Tilly, Arkansas. Lee was 22 at the time, a white supremacist linked to a group called the Aryan People's Republic. He and an accomplice named Chevy Kehoe had driven from Washington State to Arkansas with a specific plan. They were going to rob a gun dealer named William Frederick Muller, take his weapons and cash, and use the proceeds to fund a whites-only separatist compound in the Pacific Northwest. They called it the Northwest Territorial Imperative. William Muller was 52, a gun dealer operating out of his home. His wife, Nancy Ann Muller, was 28. Nancy's daughter from a previous relationship, 8-year-old Sarah Elizabeth Powell, was also in the home. Lee and Kehoe, dressed as federal law enforcement officers, forced their way inside and waited for the family to return. When they did, the 2 men overpowered all 3. What the investigation would later uncover was staggering in its cruelty. The court record described what followed as deliberate, methodical, and designed to leave no survivors. All 3 were killed. Their bodies were disposed of in the Illinois Bayou in Pope County and were not recovered until June of 1996. Lee had a prior history of violence. In 1990, at age 17, he had been involved in a separate killing in Oklahoma City, but pleaded down to robbery. Lee and Kehoe were tried jointly in 1999 in the United States District Court for the Eastern District of Arkansas. Both were convicted of 3 counts of murder in aid of racketeering. Prosecutors portrayed Kehoe as the ringleader, the more dominant figure, and the one who directly carried out the killing of the child. Despite that, the jury gave Kehoe life in prison. The same jury gave Lee death. That sentencing disparity haunted the case for the next 2 decades. Earlene Branch Peterson, Nancy Muller's mother, and Sarah Powell's grandmother, publicly and repeatedly asked the federal government not to execute Lee. She said the execution would dirty her daughter's name. She opposed it until her own death. After Attorney General William Barr ordered the resumption of federal executions in July of 2019 and adopted a new single-drug pentobarbital protocol, Lee was scheduled first. The night before his execution, Judge Tanya Chutkan in Washington, D.C., issued a preliminary injunction challenging the lethal injection method. Emergency appeals flew through the courts. At 2 a.m. on July 14th, the Supreme Court vacated the injunction 5-4, with Justices Ginsburg, Breyer, Sotomayor, and Kagan dissenting. Lee had already been on the gurney for hours by that point, waiting while the legal arguments played out. He was executed almost immediately after the stay was lifted. In his final statement, he maintained that he had not committed the murders, that he had made many mistakes in his life, but that he was not a killer and the government was executing an innocent man. A piece of evidence that his defense team raised repeatedly over the years was a hair strand found inside an FBI cap, used as a disguise during the crime. DNA testing showed it did not belong to Lee or Kehoe. The identity of the person it did belong to was never determined. The Eighth Circuit rejected this as grounds for a new trial in 2008, but the unresolved question lingered. The Mueller family, including Earlene Peterson, opposed the execution to the end. Daniel Lewis Lee was the first of 13 federal inmates executed between July of 2020 and January of 2021. And the pace that followed was unlike anything the federal system had ever seen. 3 days later, a second man was put to death at the same facility, a man whose crime was among the most disturbing cases to ever reach federal death row. Brandon Bernard. On the evening of June 21, 1999, a married couple from Ames, Iowa drove out of a convenience store parking lot in Killeen, Texas, near Fort Hood. Todd Bagley was 26. Stacy Bagley was 28. They were youth ministers who had traveled to Texas for a church revival, part of a life they had built together around their faith. A group of teenagers approached their car in the parking lot and asked for a ride. Todd and Stacy said yes. What happened over the next several hours would end both of their lives. Brandon Bernard was 18 years old that night, a low-ranking member of a local blood set called the 212 Piru. The group's ringleader was 19-year-old Christopher Vialva. There were 5 of them total, 3 of whom were minors. Vialva produced a gun, forced the Bagleys into the trunk of their own car, and the group spent hours driving around the Killeen area, withdrawing money from the couple's ATM card and trying to pawn Stacy's wedding ring. Court testimony described the Bagleys, audible through the trunk, singing gospel songs and pleading with their captors for mercy. On a remote Fort Hood training area, which was federal land, Vialva opened the trunk and shot both Todd and Stacy in the head with a .40 caliber handgun. Bernard, who had purchased the lighter fluid earlier that evening, set the car on fire with the Bagleys still inside. Whether Stacy Bagley was still alive when the fire began was a contested point at trial. The Galveston County medical examiner concluded she was medically dead from the gunshot wound before the fire started, but the prosecution argued she died of smoke inhalation. That distinction shaped Bernard's death sentence, because it meant the jury could conclude he had directly caused her death by setting the fire, rather than burning an already dead victim. Bernard and Vialva were tried jointly in United States District Court for the Western District of Texas. The case was tried federally because the crime took place on Fort Hood, which is a military installation, and therefore federal jurisdiction. On June 1, 2000, the jury convicted Bernard of carjacking, resulting in death, conspiracy, and 2 counts of first-degree murder. On June 13, 2000, both men received the death penalty. The 3 younger accomplices, all of whom were minors at the time, received prison terms. Tony Sparks, who had been 16, was initially sentenced to life, but that sentence was reduced to 35 years in 2018. Bernard's direct appeals were exhausted by January of 2016 when the Supreme Court denied certiorari. Bernard's case attracted enormous public attention in the weeks before his execution, more than perhaps any other in the series of 13. 5 of the 12 original jurors publicly called for his sentence to be reduced, saying that they would not have voted for death if they had known then what they knew now. A former lead prosecutor named Angela Moore wrote a letter saying she now believed a life sentence would have been more appropriate, citing evidence that had emerged about Bernard's low-level role in the gang. Kim Kardashian personally lobbied President Trump for clemency. Defense attorneys, including Alan Dershowitz and Ken Starr, filed last-minute motions arguing that prosecutors had withheld an expert assessment indicating Bernard was a low-level gang member and not a future danger to society. The Supreme Court declined to issue a stay, with Justices Breyer, Kagan, and Sotomayor dissenting. On December 10, 2020, Brandon Bernard was executed at USP Terre Haute. He was 40 years old. His last meal was a meat lover's pizza and a brownie. Before the injection, he looked directly at the Bagley family members present and told them he was sorry, that those were the only words that could capture what he felt now and what he had felt on that day. Pool reporters described him as calm. Georgia Bagley, Todd's mother, later said that Bernard's apology and Vialva's had helped heal her heart, and that she could say she forgave them. That forgiveness extended to both men. But Vialva had already been dead for nearly 3 months by the time Bernard was executed. Christopher Vialva. Christopher Vialva was the one who pulled the trigger. He was 19 years old on the night of June 21, 1999, the oldest of the 5 teenagers involved in the carjacking and murder of Todd and Stacy Bagley at Fort Hood. He produced the firearm. He forced the couple into the trunk. He drove the car around for hours while they withdrew cash. And when they reached the remote training area, he opened the trunk and fired a .40 caliber round into each of their heads. Court records describe Stacy Bagley telling Vialva that Jesus loved him in the seconds before he shot her. Vialva and Bernard were tried together. On June 13, 2000, the jury sentenced Vialva to death on 3 counts, with life on a 4th. The Fifth Circuit affirmed the conviction in July of 2002 in a published opinion, United States v. Bernard. The Supreme Court denied review in June of 2003. Every subsequent appeal through 2018 failed. His attorney, Susan Otto, argued the trial had been conducted before 11 white jurors and 1 black juror, and that the prosecution had leaned heavily on the late 90s super predator narrative to characterize Vialva as a violent gang leader, despite what she called weak evidence supporting that portrayal. She also argued that his neurological development at 19 should have disqualified him from a death sentence, pointing to research on adolescent brain maturation that had been published since the original trial. After Attorney General Barr's announcement of execution dates in the summer of 2020, Vialva was scheduled as the 7th federal execution of the year. He became the first black inmate put to death under the restarted federal death penalty protocol. That fact drew significant attention from civil rights organizations and criminal justice reform advocates who noted the racial composition of both the jury and the defendant in the original trial. During his 20 years on death row, Vialva converted to Messianic Judaism. He taught himself Hebrew from scratch, using books obtained through the prison library system. He spent 2 years petitioning prison officials to allow weekly religious services for himself and other inmates of the same faith, and eventually won that fight. In a recorded video message released before his execution, he said that he had committed a grave wrong when he was a lost kid, and that he had taken 2 precious lives from the world, and that every day he wished he could undo it. On September 24, 2020, Christopher Vialva was executed at USP Terre Haute. He was pronounced dead at 6:46 in the evening, Eastern Time. His last meal was Pizza Hut. His final spoken words were a prayer for the Bagley families, asking God to heal their hearts with grace and love, and ending with the words that he was ready. He was 39 years old. He had spent more than half his life on death row for a crime he committed as a teenager. Whether a 19-year-old's brain is developed enough to warrant the ultimate punishment is a question the courts never fully resolved in his case. In 2005, the Supreme Court ruled in Roper v. Simmons that executing offenders under 18 violated the Eighth Amendment. But the court drew no further line beyond that age. Vialva was 19 when he killed the Bagleys. That single year made all the difference in his case. Had he been born 12 months later, he would have been constitutionally ineligible for the sentence that killed him. But Vialva and Bernard were not isolated cases. They were the 9th and 10th federal executions that year. The pace was relentless. The one that came before them both, just 3 days after Daniel Lewis Lee, involved a defendant whose mental deterioration raised a different question entirely. Not whether someone was too young to be executed, but whether someone could be too far gone to understand it. That question would divide the Supreme Court at 2 in the morning. Wesley Purkey. Wesley Purkey was 68 years old when he was executed on the morning of July 16, 2020, the second federal execution in 3 days. By that point, his attorneys argued he could no longer rationally understand why the government was putting him to death. He suffered from fetal alcohol spectrum disorder, schizophrenia, traumatic brain injuries accumulated over decades of violence both inflicted and received, and what his legal team described as progressive dementia consistent with Alzheimer's disease. Multiple court-appointed evaluators had examined him. The question of his competency had been litigated for years. The crime that placed him on death row had occurred more than 22 years earlier, in a different century. On January 22, 1998, Purkey, then 46, was living in Lansing, Kansas, and working as a plumber. He drove to Kansas City, Missouri for a job interview. 16-year-old Jennifer Long was a sophomore at East High School in Kansas City. She had left campus earlier that day after a fight with another student. What happened next, according to the federal investigation and Purkey's own subsequent confession, was that he encountered Long on the street, persuaded her into his pickup truck, drove her across state lines back to Kansas, and took her life. The scope of what the investigation uncovered was extensive. The autopsy findings, pieced together from physical evidence recovered years later, were consistent with prolonged and deliberate harm. Jennifer Long's remains were never fully recovered. She had been listed officially as a runaway for years before the truth emerged. 9 months after Long's disappearance, in October of 1998, Purkey beat 80-year-old Mary Ruth Bales to death with a claw hammer in her Kansas City, Kansas home during a burglary. While awaiting state trial for that murder, he wrote a letter to a detective in December of 1998, offering to confess to a federal crime in exchange for being transferred out of state custody. He led investigators to the area where he had disposed of Long's belongings, including clothing and a jawbone fragment. He was charged federally in October of 2001 with kidnapping a child resulting in death. His trial took place in the fall of 2003 in the Western District of Missouri. On November 5, 2003, the jury convicted him. On January 27, 2004, he was sentenced to death. He had separately received a life sentence in Kansas State Court for the Bales murder. Purkey's appeals focused almost entirely on his mental state, and they presented a genuinely difficult legal question. His attorneys cited the Supreme Court's rulings in Ford v. Wainwright from 1986 and Panetti v. Quarterman from 2007, both of which held that the Constitution prohibits executing a prisoner who lacks a rational understanding of why he is being put to death. Neurological evaluations conducted by defense experts described severe cognitive decline over his years on death row. His legal team argued he no longer understood the connection between his crime and his punishment, and that executing him under those conditions violated the Eighth Amendment. On July 15, 2020, Judge Tanya Chutkan issued a preliminary injunction blocking the execution, finding that Purkey's mental competency claims deserved a full hearing. In the early morning hours of July 16th, the Supreme Court vacated that injunction 5-4, clearing the way for the execution to proceed immediately. Purkey was executed at USP Terre Haute and pronounced dead at 8:19 in the morning, Eastern Time. In his final statement, he expressed deep regret for the pain and suffering he had caused to Jennifer Long's family and said he was deeply sorry. He also spoke of his daughter, saying he loved her. He then called the execution a sanitized act of murder that served no purpose whatsoever. Jennifer Long's father, William, responded publicly that he hoped Purkey would rot in hell. He had waited more than 22 years for that morning. Purkey was the second of the 13. He was executed on a Thursday. The very next day, a Friday, the third execution took place. A man from a small town in Iowa whose crimes had gone undiscovered for nearly 7 years. Dustin Honken. In the early 1990s, a community college chemistry student from Britt, Iowa named Dustin Honken figured out how to manufacture methamphetamine at near pharmaceutical purity. He was 24 years old. Within a year, he and a childhood friend named Tim Cutcomp had built a distribution network stretching across northeast Iowa, supplying dealers in multiple counties. By the standards of rural methamphetamine operations, Honken's product was considered exceptional. He was not a small-time cook. He was running a serious enterprise. In March of 1993, Honken was indicted on federal drug trafficking charges. Through pretrial discovery materials, he learned the identity of his main confidential informant, a local dealer named Greg Nicholson, who had been cooperating with the DEA. That discovery set in motion the murders that would eventually put Honken on death row. He decided that every potential witness against him needed to disappear. On July 25, 1993, Honken and his girlfriend, Angela Johnson, kidnapped Greg Nicholson, 34, along with Nicholson's girlfriend, Lori Ann Duncan, 31, a Navy veteran and single mother. Lori's two daughters, 10-year-old Candace and 6-year-old Amber, were with them. All four were driven to a wooded area southwest of Mason City. The adults were bound and killed. The children were killed alongside them. What the court record described was deliberate and premeditated. All four were buried together in a single grave. 3 months later, on November 5, 1993, Honken lured a former dealer named Terry DeGius to a field and killed him as well. DeGius was 32. The bodies were not found for 7 years. It was not until 2000, after Cutcomp cooperated with investigators and wore a wire, and after Angela Johnson made incriminating statements while in custody, that police located the graves. The discovery of what had been done to the Duncan family, including 2 children whose lives were taken to eliminate a witness, became the central weight of the prosecution's case. Honken had pleaded guilty to drug trafficking in June of 1997 and received 27 years. He was indicted for the 5 murders in 2001 and tried separately from Angela Johnson. Because Iowa abolished its state death penalty back in 1965, only federal law, specifically the Continuing Criminal Enterprise Statute, allowed capital prosecution. Without that federal hook, there would have been no path to a death sentence in the state of Iowa. His trial took place in 2004 in the Northern District of Iowa in Sioux City. On October 14th, the jury convicted him on all 17 counts, including 5 counts of murder in furtherance of a continuing criminal enterprise. The jury recommended life sentences for the adult victims and death for the murders of Candace and Amber Duncan. He was formally sentenced to death on October 11, 2005. Angela Johnson was also sentenced to death, the first American woman to receive a federal death sentence in 50 years. But her sentence was vacated in 2012 and reduced to life in 2014. The Eighth Circuit affirmed Honken's conviction in 2008. He converted to Catholicism while on death row. On July 17, 2020, Dustin Honken was executed at USP Terre Haute, pronounced dead at 4:36 in the afternoon. He was the 3rd federal execution in a single week, and the first Iowan put to death since 1963. His last meal was a Pizza Hut order totaling $33.11. For his final words, he recited lines from a Gerard Manley Hopkins poem about desiring to go where springs do not fail, and he closed by asking the Virgin Mary to pray for him. He was 52 years old. He had been a meth cook, a witness eliminator, and by the end, a man who spent his last breath reciting Victorian poetry in a federal death chamber in Indiana. The jury that sentenced him to death did so specifically for what was done to those 2 girls. Not for the drug empire. Not for the 3 adult victims. For Candace and Amber Duncan, who were 10 and 6 years old, and who were buried in a hole in the woods outside Mason City because their mother's boyfriend had talked to the wrong people. Their bodies lay undiscovered for 7 years. Nobody came looking for them until it was far too late. Thanks for watching. Click here to see our next video.